The first thing I would like would be the judges to turn your cameras on, and as well as Attorney Del Campo, who I see, but that would help us a little bit. And why don't we first take a roll call of the members of the committee, Attorney Del Campo?
Yes, Your Honor. Attorney Avery Whetstone, Judge Avery Whetstone. Judge Bellis.
Present.
Judge Cobb.
Present.
Judge Farley.
Here.
Judge Hernandez. Judge Nguyen O'Dowd.
Present.
Judge Prats.
Present.
Judge Trulia. That's it, Your Honor.
Thank you. And I'm sorry, I had Judge Trulia not here, Judge Hernandez, and who else?
Avery Whetstone.
Thank you. And I understand that Judge Cobb is doing double duty today, watching another judge's courtroom. So she may have to, there's Judge Trulia. So she may have to step out of the meeting for a moment. Okay, before we begin, I just wanted to first ask members of the committee, now that we are happily, if not perhaps temporarily, emerging from COVID-related protocols, would members like to continue to have the meetings on Teams, or would there be any interest in returning to the courtroom, which I know is inconvenient for several members of the committee to get to for a relatively short meeting? But I didn't want to proceed without at least addressing the issue so that we have an understanding of what the preference of the members of the committee is. Judge Bellis, you were going to comment?
I was. I have no preference. I would say this saves a lot of travel time for those of us who are far from Hartford, but I would defer to everyone else.
Does anybody have Judge Trulia?
I would like to mix it up a little bit. I think that the remote works very well for everybody. I can see that. It certainly helped me here in Bridgeport, but I think we should meet in person maybe every once in a while, maybe every third meeting, something. I think it's probably a good thing to try to keep up. That would be my suggestion.
I like that idea. Is there any objection to Judge Trulia's maybe every third meeting or something? Okay. Why don't Attorney Del Campo, that's not a problem, is it?
No, sir. No, we can do that, certainly.
Okay, we'll check with Judge Avery Whetstone and Judge Hernandez as well. But if that is how, well, and we're also approaching the end of the year of our meetings anyway, so maybe that's something we begin at the next court year. But I'll keep that in mind. Thank you, Judge Trulia, for that suggestion. The first item on our agenda is the approval of the minutes from the February 7th, 2022 meeting of the Rules Committee. Is there a motion to approve?
So moved, Judge Bellis.
Is there a second?
Second.
Are there any changes or modifications to the minutes? If not, all in favor, please raise your hand. Actually, Judge Nguyen O'Dowd, is that okay with you as well?
Yeah, my hand's raised.
Oh, I don't have you on a camera for some reason. Okay. Thank you. That passes unanimously. The next item is 2021-18, proposed revisions to the practice book, rule section 2-16, attorneys approving pro hoc vice. Attorney Del Campo, we have some new materials.
Yes, Your Honor. This was last on the agenda in January. It was tabled. It was referred to the Chief Court Administrator and to Attorney Begeman for the Appellate Rules Committee. Attorney Begeman is the Director of Appellate Operations. This rule was intended to comply with an already changed and effective appellate rule. And you had asked that it be tabled and referred to Judge Carroll because one of the sections of the revised rule 216 deleted the responsibility of the chief court administrator to prescribe the forms that were necessary, the applications that were necessary under this rule. And you had wondered whether or not you wanted me to go to Judge Carroll to determine whether or not he agreed with that or not. You wanted also to go to the appellate rules committee, or at least Jill, to review the rule to make sure they didn't have any concerns with the rule as compared to their own, which is 62-8A. I have, since the last meeting, discussed with court operations the intent of their proposal. It did not seem that they were as concerned with Judge Carroll's authority being deleted as they were with just simply citing to the correct forms that should be used. Even if prescribed, they wanted to make reference to the form so that whomever was needing these would get them. I discussed that with Judge Carroll. He has no, and we put back in this revised proposal, his authority has been put back in as well as mentioning the specific forms. He would still like to prescribe the forms that are necessary. As far as the appellate side of things, Attorney Begeman did bring it to the appellate rules. They have a work group, not the advisory committee, but a work group, and they did review it. They saw no issues other than some technical issues, which if you move it along, I will consider and fix if necessary. But they saw no substantive issues with it and no conflict with their own rule. So that's the summary.
Thank you for that summary. Are there any questions for Attorney Del Campo from members of the committee?
My only question is, this is Judge Pratt's, why in criminal is there no prompt for the filing of the fee? Because I know in criminal that's been a little bit of an issue, getting the attorneys once they're in to pay afterwards.
I don't know the answer to that, Your Honor.
Okay, and I know it's just I was just wondering about that. Okay, thank you.
Attorney Velez? Judge Velez.
Just a comment, I support it. There's just one typo in subsection 1. It says seeing permission to appear pro hoc vici, and obviously it should be seeking, but otherwise I think it's excellent and I support it.
Okay, well, understanding as Attorney Del Campo said that there may be needed some additional cleanup language. Judge Prats, are you okay moving forward as he figures out the criminal aspect of that?
Yes, of course. I was just wondering why. I just saw that in the comments as well.
Okay, so is there a motion to approve?
So moved. Judge Prats.
It's been moved by Judge Prats and seconded by Judge Velez. Is there any further discussion, understanding that there are going to be some editorial tweaks? If not, all in favor, please raise your hand. Opposed? That passes unanimously. Thank you. Next is the proposal to amend practice book section 7-10 and 7-11 regarding retention and destruction of summary process records. Could you bring us up to speed, Attorney Del Campo?
Yes, Your Honor. This first came to the committee back in December. It was tabled and referred to the Chief Court Administrator and the Judges Advisory Committee on e-filing for consideration and comments. Judge Carroll called a meeting of the Advisory Committee. It came back to you with their comments. It was again considered in February and tabled and referred to court operations, Judge Abrams, and various tenant and landlord associations. Since that time, Attorney Giovanna Shea has submitted additional comments on the proposal, and there is a raised bill in the legislature, raised bill number 200, which I believe is part of your package, which is being considered to deal with this, some of these concerns. Attorney Shea is here, I believe, for additional comments, if you'd like them.
Yes, Attorney Shea, if you could turn on, thank you very much. Very timely. So I appreciate you attending. Given, I guess my first question is, given the fact that this is a pending legislative proposal, is there any reason we wouldn't wait for the legislature to see if they act on Senate Bill 200?
Well, we would certainly ask that this committee table the proposal in terms of whether or not the General Assembly passes the legislation. And it was voted out of committee with a joint favorable substitute language last week. So it appears at the moment to be moving forward. Regardless of what happens with that legislation, the judicial branch, well, if it were to pass, the branch would need to consider an amendment to the practice book rules, which I guess this committee would consider. If it doesn't pass, we would like the judicial branch still to consider doing this by an amendment to the rules. I don't think legislation is required to change a policy that is set by judicial branch rules. So either way, I think that we would ask the committee to hold it for now.
So I appreciate that. And I certainly agree. We have our own independent authority and responsibility, but on something like this that is at a minimum is a shared responsibility, my preference would be to allow the legislature to act on it first as elected officials. So I would recommend to the committee that we table this, take no action on it, probably for the rest of this year for our activities, see what the legislature does by its adjournment in May, and either readdress the issue or address it to bring it into conformity with anything that the legislature has done in the interim when we begin again in September. Does that sound like a plan? I'm seeing many heads bobbing, so I will take that as a yes, and I appreciate that update, Attorney Shea. So we'll table this until the beginning of the next court year.
Thank you. And Justice McDonald, if I can just alert the members of the committee, you and Judge Bellis had asked about the practices of other states, and we did include some information about that in the packet. So to the extent that committee members are interested or that's helpful going forward, I just wanted to alert you to that.
I saw that. Thank you very much. I appreciate it. Okay. The next item on our agenda is 2021-027, proposal to amend the practice book to include uniform standard interrogatories and production requests for real property tax appeals. Attorney Del Campo, I saw we got an email.
Yes, Your Honor. This was last on the agenda in January. It was tabled and referred to several different associations that might have an interest in this. Connecticut Association of Municipal Attorneys. It was also referred to Judge Abrams and the CBA, and the presiding judge, chief administrative judge for administrative appeals, Judge Cordani, which he did submit comments to you with a copy to Judge Abrams. And yes, today you received a correspondence from Attorney Greg Servaldidio. He's chair of Pullman and Comley's Property Tax and Valuation Department, and he represents taxpayers and municipalities. That department represents taxpayers and municipalities in tax appeals, and they are asking for time to review this and to offer comment.
So did we get any feedback from the CBA or no?
I did not. I looked several times. I did not. I don't know if Mr. Chapman is on the call.
He is. Attorney Chapman, are you available? There you go.
Yes, hi, how are you? No, we had a planning and zoning group look at it, and they had, they were not going to make any comments.
And I see Attorney Deneen is on as well. I saw that you had written a letter to us as well. Let me ask, I mean, it doesn't seem like that the plaintiff's bar is as organized as municipalities. To your knowledge, is there any kind of informal or formal group of individuals who typically represent taxpayers in the state?
Thank you, Justice McDonald. I'm not aware of them. There's a relatively small group of plaintiffs' attorneys that generally are out there, but I'm not aware of any formal or informal coalition or grouping of those.
No, nor am I. I will full disclosure. I used to be a partner at Pullman and Comley and
Mhm.
did tax appeals. I knew they had a group. I think McCarter English has a fairly active tax appeal practice as well. It's perhaps unfair of me, Attorney Deneen, but I guess I would ask if you would be kind enough to work with Attorney Del Campo to try to come up with a list of, at least a representative list
Sure.
of the attorneys who represent taxpayers, so that they could at least informally get together and try to give us some feedback on this proposal for our next meeting.
I'd be happy to, Your Honor. I think as the president of the Municipal Attorneys Association, we had very similar reaction, I think, to Attorney Servidillo, of just wanting to take a look at that there's a very strong support for developing some standard interrogatories and production as part of this process, because it gets very ad hoc in some ways on that. And so I'd be happy to work with Attorney Del Campo and see if we can drag in some of the plaintiffs folks too.
Yeah, I'm assuming that this is not considered to be exclusive. I mean, doing a residential tax appeal is different than doing a tax appeal on a nuclear power plant.
Correct.
So at least we could hopefully get to some baseline understanding of some minimal interrogatories or production requests that could be supplemented in other areas.
That would be that's what we're all working to.
Okay, is there any objection to members of the committee if we just table this for now till at least next month?
Your Honor, can I just
Yes.
a reminder that next month there is no meeting. There's a meeting in May, but it's the public hearing meeting. So if this went beyond this meeting, it wouldn't get on for public hearing, and then you wouldn't be able to pass it except as an interim rule. So I don't know the urgency of it. Judge
Cordani doesn't think there's any urgency that we need it at all. So Attorney Deneen, I assume the sky won't fall if we spend next few months trying to organize ourselves in an orderly fashion.
We've lived without it for quite a while. We'd like to try to get it right if we could. So.
That's an admirable goal. Okay, thank you for catching that, Attorney Del Campo. I appreciate that. The next item on our agenda is 2022-003, proposal to amend Practice Book Section 2-27D to include the DRS as an agency that would have access to non-public information regarding attorneys and their occupational tax. Attorney Del Campo.
Yes, sir. This was on February 7th. It was tabled and referred to the Chief Court Administrator and the Connecticut Bar Association. Deputy Commissioner Biello, who I believe is on the call, he had coordinated reviewing this with the CBA, and he actually submitted a revised proposal which incorporates the CBA's any concerns that they may have had with the original proposal. Judge, the comments from Judge Carroll are in your package. Basically, he indicates that he had this was broached with him several months ago by the Commissioner's office, and he supports it. So it was to go out to those two entities, and they have come back with comments. And I believe that the Deputy Commissioner is on the call.
I believe he is. If you could turn on your camera, please.
Good afternoon, everyone.
Good afternoon. Anything you'd like to address to the committee?
No, we did our due diligence with the CBA, and we came to an agreement regarding language. So this will greatly help the agency administer the attorney's occupational tax in a fair and equitable manner. So I think we're in a good place, and all parties agree to the language that's been set forth.
And just so we're clear, are we talking about Attorney Del Campo 2022-003D?
Yes, we are.
Okay. Okay.
Nice proposal.
Do any members of the committee have any questions of the Deputy Commissioner with respect to item D? If not, is there a motion to approve?
So moved, Judge Bellis.
Is there a second?
Second.
Seconded by Judge Truglia. Any discussion? All in favor, say aye or raise your hand. Opposed, raise your hand. That passes unanimously. Thank you very much, Deputy Commissioner.
Thank you all.
Okay, the next item on our agenda is 2022-006, proposal concerning Rule 2.11 of the Code of Judicial Conduct. Attorney Del Campo.
Yes, Your Honor, this is the first time this is being considered by the committee. It was submitted by Attorney Begeman on behalf of Judges Prescott and I can't remember.
Justice Doria.
Yes, it is a request to revise section 2.11 of the Code of Judicial Conduct. There is a new appellate rule being considered, and this suggestion will cause the two rules to come into compliance and to be consistent, I guess, with the appellate practice regarding judicial disqualification. I don't believe Attorney Begeman is on this call, but that's and you have the proposal in the package.
Attorney Del Campo, I guess
Yes.
the strikeout language seems, oh, wait a minute, maybe, okay. I thought the strikeout included 4 in 4-8, but it does not. Okay.
No, it doesn't.
Okay. Are there any questions from members of the committee? Are we clear about what this is accomplishing?
I confess I'm not. So is it consistent? When I read it, I thought there was inconsistency on the requirement. I thought it would still require a hearing at the trial court level when the trial judge had been sued or a complaint had been filed. And then the same litigant making, or the same attorney or same litigant making the same, judicial review complaint, or you're in the same lawsuit, there's no hearing at the appellate level.
I believe that's correct, Your Honor. There's different.
Is that intentional? Is that what we want to do? That's, I guess, my question. Because we're often sued all in one lawsuit, the appellate judges and the trial judges. And I'm just wondering is that something we should even address, or?
I'm just trying to, I'm not entirely clear what the evil is we're trying to cure.
If I can explain a little.
Sure.
The the 1-22 requires that the judicial official either disqualify himself or herself, conduct a hearing on the disqualification issue before deciding whether to disqualify himself or herself, or refer the disqualification issue to another judicial authority for hearing and decision. The appellate rule, the proposed new appellate rule, would only require that the justice or justice who is subject to the disqualification issue either decide whether to disqualify himself or herself from acting in the matter, or refer it for disqualification to another justice. There's no hearing that's going to be required under that rule. They just want to disqualify or not, or give it to somebody, another judicial authority to do. So those two rules are not being affected by any of this, other than to say that 2.11 requires, once the judicial authority knows of this, to put it on the record. The appellates don't apparently do that at this point, and would prefer not to do so under 2.11.
So Justice Doria is 2 doors away from me, and I have not talked to him about this. Is there any objection if we table this for this month, so I can, I don't for this month until the next court year, until we can figure out what's motivating this? It's not entirely clear to me. Is there any objection to that?
No objection.
Okay.
Your Honor, just I will say once again, I'm sorry to interrupt. So if it doesn't come back until May, it can't come back in May if that's what you decide. It will just be, if approved, it'll be interim.
Got it.
Okay.
Okay. Thank you. All right. So the next item is 2022-007, proposal from the Connecticut Bar Foundation to revise practice book Rule 1.15 regarding the annual mailing requirement to allow for electronic distribution of the annual report. Attorney Del Campo, I believe Attorney Wagner is also with us. You're muted.
Sorry, my apologies. First time being considered. It is basically to allow the Connecticut Bar Foundation, which is the entity that has been designated to administer the IELTS program, to fulfill its obligation to give each judge of the Superior Court a detailed annual report by electronic means. They were allowed to do this during the pandemic. It worked rather well. Attorney Wagner has proposed it to become permanent, and you see the proposal in the package. Attorney Wagner is here.
And it's always good to see her. Good afternoon, Attorney Wagner. Anything you want to add to this discussion?
No, I'm here merely to answer any questions that the committee may have about it, but thank you very much for considering our proposal.
Supposedly or purportedly, this would be helpful in saving some money, right?
I'm hopeful both for that and just to make sure that, it gets to people in the way that is most accessible to them, basically. We want the judges to read it, so we're hoping this will, in fact, make it easier.
Thank you. Are there any questions for Attorney Wagner? Judge Farley.
So what was done during the pandemic, not that it's over, but was emailed to the judges. But what's being proposed now would not be emailed to the judges. It would just be in the Bar Journal. So I'm just wondering, and I understand there was some issue about whether the listserv could be used for this. I think in terms of getting it to judges, it would be more effective if it went out by email. Just wondering why we're not doing that.
Attorney Wagner.
Yeah, of course. Thank you, Justice McDonald. And thank you, Judge Farley, for your question. So we went through a couple different options. I had reached out to Melissa Farley in the External Affairs Division specifically, and she talked it over with the Office of the Chief Court Administrator. And the intranet and the listserv it was determined that while we were allowed to distribute it that way, on sort of a one-time dispensation, that was not appropriate for an ongoing use. And so her office suggested that we make this proposal instead. And it would provide through the Law Journal a link that judges could use to access it directly on our website. So that's what was suggested, and we adopted with our proposal.
Judge Farley?
Well, I don't know. I'm not sure that everybody's gonna see it in the Law Journal, put it that way. And I don't know. I don't know what the concerns are that the administration has. So it's really hard to speak to.
I'll ask the question. I mean, what's the impediment, Attorney Wagner? I mean, why is it considered inappropriate?
I was told that it was that the listserv is mainly for distribution of internal branch news rather than distribution of materials from external sources.
And to further supplement things, Attorney Farley has joined us. I appreciate her rapid response.
Good afternoon, everyone. So as you may know, we use the judges listserv for internal communications. And to be quite honest with you, we have had requests from many organizations for us to send information to the judges. So we have a strict policy that is really only used for internal communications. And during the pandemic, we made an exception for the Bar Foundation because we thought it was really too cumbersome for them to mail all this information out. And it was a one-time exception to send the report to all the judges using the judges listserv.
See, Melissa always has good answers. Attorney Wagner, I mean, would it be we all know how judges' emails work. Would it be unworkable for the foundation to not keep an active list of the judges for purposes of emailing it separately?
No, I mean, certainly we could request a list annually and distribute it by email if that is what the Rules Committee would prefer. We have no problem with that.
I would recommend that we pass this as proposed, and with a nod and a wink to the foundation to ask them to separately send it by email to the judges. Would that accommodate everybody's concerns?
Yeah, I mean, Justice McDonald, I mean, my understanding is that I think our emails are all on the judicial website. There's a list of judges and our.
To many people's chagrin, probably. Okay.
Your Honor,
Yes.
I'm just pointing out that the rule talks about mailing it to each judge. That has been interpreted as post office mail, I believe. I think that's the impetus for the change, because it was discussed that that they had to mail it. They still mail it to attorneys who are participating in the program, I believe.
That's correct.
It's going to be a change to that process.
Right, but this is now just going to be put in the law journal, as I understand it, and separately, the foundation would take it upon itself to email something.
Oh, okay. All right.
We're not doing the mail anymore. Okay. All right. With that understanding and with gratitude to Attorney Wagner for taking on that additional responsibility, is there a motion to approve this?
So moved, Judge Bellis.
Is there a second?
Second, Judge Truglia.
Seconded by Judge Truglia. Is there any discussion? All in favor, please raise your hand. Any opposed, please raise your hand. That passes unanimously. Thank you very much, Attorney Wagner.
Thank you, everyone.
Next is item 2022-008, proposal by the Connecticut Bar Examining Committee to amend various practice book rules to offer admission via the in absentia process as an option for candidates. Attorney Del Campo.
Yes, Your Honor. This, again, is first time being considered, but it's a process that was developed because of the pandemic. And it was initially very labor intensive for legal services personnel, and took some judicial resources. Judge Carroll ultimately issued a standing order in this situation, which uses less judicial resources, obviously, and less administrative resources. But it came to be that this is one of the preferred ways to do this, and the Bar Examining Committee would like to continue this permanently. Attorney Harrington, who is the Deputy Director in Legal Services in charge of attorney services here, is on the call if you'd like to ask her some questions.
Thank you. Attorney Harrington, would you like to address this item for the committee?
Thank you, Your Honor. I really appreciate that we were placed on the agenda so quickly. The only things I would like to add are just a sincere thank you to Melissa Farley and the Chief Court Administrator's Office for assisting us with this issue. It has been highly successful with our candidates for admission, and over the last approximately 2 years, we've had about 898 individuals admitted in absentia through this process. So these proposals would simply be codifying what the current process that we're already undertaking.
Any questions from members of the committee? So let me ask, you said 800 plus have been admitted in absentia?
Yes, Your Honor, 898.
Okay, and as compared to what total?
For a normal year, I'm sorry, Your Honor, off the top of my head, I probably always have over 1,000, at least a minimum every year being admitted.
So this is a majority of the candidates.
Correct, Your Honor. I mean, mainly from 2020 through most of 2021, it was essentially all of our candidates. The in-person ceremonies started again, I believe. We've had 2 for the bar exam applicants, but we had to suspend that during the height of COVID.
Right. I mean, you know, it's a meaningful ceremony for the candidates and their families. This is a totally separate and voluntary avenue. If they still want to do the in-person ones now that they're reinstituted, that's still available. Is that right?
Correct, Your Honor. After the last bar exam, when we recommended candidates, we invited them to the ceremony, but gave them the option to opt out. Some individuals are out of state, and some might need to be admitted as soon as possible for jobs or military service. So we did still have a significant amount of applicants participate in the in-person ceremony. As Your Honor noted, it's a very important ceremony. They do a lovely job, and a lot of people do like to come in person and bring their parents or significant others with them.
Okay. I know this is on our agenda for the first time, but does anybody see any reason why we couldn't approve it now? Or do you think this needs to be referred out to anybody for consideration? Judge Farley.
Well, I read that it had been sent to CBA for their comments, but I don't know whether they've responded or not.
Thank you, Your Honor, for raising that. So Melissa Farley had indicated to us that the CBA had no objection and supported it. The Bar Examining Committee supports it, and we did send it to Attorney Bowler for the statewide grievance committee. He wasn't able to send it to his committee, but he noted that he does not have any objections to it, that it's also been a very successful program and working smoothly on their end of issuing juris numbers.
Any further questions or concerns?
Not knowing the process, can I ask a question?
Sure.
How's it done, like in absentia? So does an attorney take their oath and then the paperwork submitted, and is it effective when the paperwork is submitted to you, or how is that work?
That's a great question, Your Honor. So we send them the affidavits plus the bar card, and they, depending on where they are, whoever is authorized to administer an oath in that jurisdiction may do so, whether it's an attorney or a notary public.
Okay.
They complete both affidavits and they sign the attorney card and they submit it to our office. Now, their admission date will be the date that they took the oaths. So the date that's on the affidavits. However, they need to return them to our office so that we can process the paperwork and have that admission date recognized and a juris number issued. So there is like a slight lag time, but the official date, they can hold themselves out as an attorney after having taken the oaths, but they won't have a juris number yet, and it won't be recognized by the branch yet, since it does take a little bit of processing.
And there's been no issues with the lag time with attorneys trying to get into court with filing an appearance without or anything like that?
Thankfully, Your Honor, no. Some people drop the paperwork off to our office, and
Okay.
since we've been able to streamline things more, I'm doing it on a weekly basis where I am transferring all of that information to the statewide grievance committee, and they are issuing juris numbers on a weekly basis. We've even shared with candidates their ability to find out their juris number online within 24 hours of it being issued. So we haven't run into any problems, thankfully.
All right, thank you.
Thank you.
Any further questions? If not, is there a motion to approve?
So move, Judge Bellis.
Your Honor, just one change on page 3 of the revised proposal.
Hang on, Joe.
Oh.
Let's get the second.
All right.
Is there a second?
I'll second Judge Pratt's.
Thank you. All right, Attorney Del Campo, we have it moved and seconded.
Okay, my apologies. Yeah, on page 3 of the revised proposal, there is one correction to be made in subsection C. It's a new subsection, third line down. At the end of the line, it says duty, that should be duly, official duly qualified to administer oaths. So I'll make that change. Judge Bellis caught that as well as others. So thank you.
And I consider that a friendly amendment for a Scrivener's error. Is there any further discussion? All in favor, say aye, or raise your hands. I'm sorry. Opposed? That passes unanimously.
Thank you.
Thank you. Is there anything else we need to attend to today, Attorney Del Campo?
No, Your Honor.
All right, I will accept a motion to adjourn.
So move, Judge Bellis.
It's been moved and seconded by Judge Pratt. I see her paper is in full blossom there. All in favor, say or raise your hand. All right, opposed? That passes unanimously. Thanks, everybody, and have a great afternoon.
You too,
Bye-bye.
Andrew.
Thank you.
Bye-bye.